Bailey.
Good morning. May it please the court, Paul DeKay appearing on behalf of the appellant William Shane Parrish. This appeal really involves two main issues. The first one is the inducing of a plea, an inducing a waiver of constitutional right to jury trial out of a fear of a harsher sentence due to having a trial. And the second issue is the misrepresentations of trial counsel about the advantages of waiving the right to trial and the court not hearing certain evidence and then later holding a sentencing hearing about 30 days after the plea, and then all of that evidence that trial counsel had told the defendant at the time could be detrimental to his sentence all comes in. This really calls into question, and I know this court and the Supreme Court and the other district courts of appeals have done a lot to ensure that pleas are knowingly and voluntarily made, as the plea colloquies tend to get longer over time.
But post-sentencing here, you have to establish that the trial court abused its discretion by not finding a manifest injustice in this situation. That's a pretty heavy burden.
It is. It is a heavy burden, but
your client, actually it seems oddly, is only charged with resisting with violence in this case.
yes.
And yet, when I read through the arrest report and the discussion at the plea as to what was done, he's an addict in possession of oxycodone who, probably having already been taken into custody, escapes, runs, an officer is kicked, an ankle is broken, a plate and 5 or 6 screws is installed in the officer's leg. I mean, this, if you withdraw your plea here, this could be at a minimum battery on a law enforcement officer plus additional charges.
The drugs were charged and dismissed.
Right.
Because the defendant was free to leave. And when he left and chose to run instead of walk, 15 of them chased him, tased him about 17 times. So the battery and law enforcement officer was also charged in a separate and dismissed, because it just didn't happen that way. Now, I'm not here to argue the merits of the case. I want an opportunity to argue the merits of the case, and I'm willing to argue the merits of all 3 in front of a jury. My client wants that opportunity. But my client was told, hey, if you go to trial, they're going to see these pictures. But they didn't have the pictures at the day of the plea. This was day of trial that the plea was induced. The day of trial. If you go to trial, the doctor is going to testify in a resisting case about injuries. And as I advance in my theory, I do not believe that that would be relevant information in a resisting with violence.
The jury's going to have to decide that for the guideline score sheet.
Well, first the judge is going to have to decide it on an objection or a motion in limine, whether or not, because my argument at that time would be, then, Judge, I need to see all the medical records. But medical records in injury is not a component of a resisting with violence.
But constitutionally now, it's the victim injury points on the score sheet have to be resolved by the jury unless your client's willing to stipulate that they were severe rather than moderate.
Well, they were scored. I mean, that was taken.
They were scored as moderate. And this is a man with a permanent plate in his leg. The jury could easily have found that to be severe.
And they could. And maybe they will. But he never got the opportunity for the jury to find that. And that score sheet, there is no argument on the record about the scoring of the injury. That's scored by the state.
Because it was a plea.
The record doesn't say that. The record does not say that.
You can't invoke a jury to get a score sheet for a plea. So sure, the record doesn't say that.
And I'm not willing to agree with the statement by Your Honor saying that it was scored that way because he pled. Because there's nothing in the record, including the hearing that we held, on the motion indicating that there was any bargained for exchange in that plea. The record is completely devoid of any bargain for exchange for a plea between the state and the defendant. This was purely an exchange between the defendant and his attorney. And again, there's a fine line between what is an inducement or a promise and what is advice. Because the defendant is asked, has anybody threatened you or made any promises? Well, was it a promise that the attorney made when he said, was it an implied promise that the judge wouldn't hear this information and see these photographs if you plead versus going to trial? Or was that just advice, privileged advice between an attorney and his client? And I could sort of boil it down to, I believe, a simpler, much cleaner analogy, because I've been doing criminal defense in several states for 15 years now. And if I were to go to a defendant and say, hey, we have a child victim here. Now, I would be correct in this advice. If you go to trial and that child gets on the stand and testifies, I believe the judge would have a reason, and it doesn't happen here, but in other states, depart upward. Okay, that would give the judge a reason to depart over the guidelines. In Michigan, the guidelines, there's upward and downward departures. So it's my advice to you that you tender a plea so that that child doesn't testify about what happened to him or her. And then I set a sentencing hearing 30 days later, and guess who comes to testify? The child. And gives all the same or even more damaging testimony, because the rules of evidence are less during a sentencing hearing. Okay? I have just misadvised my client, because I said you should do this, and that's solid advice in my view. It's solid advice. Look, you don't want this child getting on the stand and testifying in front of a jury or even in front of the judge. But then to turn around and place my client in the position where that scenario happens, I have misadvised my client. And in Florida, misadvice to this level makes the plea involuntary.
This is just because of the photographs.
Not just because of the photographs. He indicated that a doctor would testify. He was afraid a doctor would come testify about the injury. Okay? I don't know, and we don't know, because the judge never got the rule on an objection to that information coming in. Because my view is if the judge were going to allow a testimony from a doctor or even from the officer about his injury, then I'm entitled to discovery of the medical records to see what the extent of the injury is. In the medical records would be if he had had a prior injury there or a recent injury there. I mean, there's a myriad of information. In my experience, I have seen police reports say this happened, then I get ambulance report and ER nurse reports where they say, I slipped and fell. When they say, what happened? Oh, I slipped over a curb. Rather than I was kicked, which is what happens later. Now, that usually happens.
Did this lawyer represent to his client that the officer wouldn't come and testify at the sentencing hearing? This was an open plea agreement.
It was an open plea, but he didn't represent. He represented, it's in the transcript from the hearing. He was concerned about the officers testifying at trial, a doctor testifying at trial, and the photographs coming at trial. Okay, now I've got to sort of try to take the court back to where they were on that day. They were there for trial. There were 18 witnesses at court, ready to go. You had a defense attorney who was clearly not prepared for trial, and the defendant testified. He was told his only option was to plead. And the defense attorney testified he was concerned about a doctor testifying. Well, there's no doctor, there's no expert disclosure, there's no doctor listed on the state's exhibit. Now, I requested as part of the record on appeal, because it shows in the docket sheet, in the docket report, 18 subpoenas. And of course, they're not in the record anymore. We looked everywhere. The clerk looked everywhere for them. But they're listed there. Just like this court also asked, almost put a hold on this because there was no order entered on the motion, written order entered on the motion for, there was, it's March 27th, it's on the docket sheet, it's gone. Now, I got a much longer order instead of the one page that had once existed from the judge.
So your position is that you or your predecessor got an earlier order?
It's on the docket. There was I couldn't find it. I don't think the judge sent it to us, mailed it to us. But I wouldn't have filed an appeal. I mean, you got to attach the order to the notice of appeal.
And you filed the appeal, but you don't actually, no, actually, in a civil criminal case, you don't attach the judgment and sentence or whatever you're appealing.
I mean, I probably do it the same way I do everyone, but I recall seeing an order. Now, it's not in my file, but I recall seeing an order that was in line with, for reasons stated orally on the record, the motion is denied.
All right.
Okay, and the reason stated initially orally on the record was credibility. But that credibility determination, it bodes in my client's favor, in the appellant's favor. Because the attorney, you know, he testified that the main reasons for his concern were that these people and these pictures were going to come in, even though he later testified that he didn't even receive the pictures. He didn't even have full discovery. He didn't even request full discovery until the day of the sentencing hearing. And that's why I know my reply brief is a bit on the sarcastic side, but if you look through the sarcasm, it's true. It's 100% true. If you're going to do a plea colloquy with a defendant, and there's going to be a later sentencing hearing, and he was just told that it's to his advantage that he pleads guilty so that this information doesn't come before the court, and then you turn around and do 30 days later after that, and all that information comes in, well, you have to tell him, the judge just said, look, by the way, we're going to have a plea hearing on this, and these people are going to testify. Were you told they weren't going to testify? I mean, I understand that a standard plea usually is plea and sentencing immediately. Now, these are guidelines of 19 months versus the 48 that he received. And I'm sorry, Your Honor.
I don't know, I was thinking it was 42, but...
It might have been 42. I know it was close to 4 years, just shy. You may be correct on 42 months.
But one way or the other, he knew when he signed the plea form that the best he could get was 19 months in prison.
Well, he testified that he was told that he was going to get probation, hence the hearing to try to get a departure.
Well, he signed a plea form that guarantees him 19.2 months in prison, because that's the minimum amount, and there's a clear statement in it that there's not going to be a downward departure effort in the written form.
Well, again, then that goes to, if the form states that there's not going to be a downward departure, then why have a departure hearing? Why would the court set a departure hearing?
I don't think there was a departure hearing in this case.
Well, there was a sentencing hearing where there was a departure
hearing, yeah.
Where a departure was requested, and that was the reason for bringing in the doctor on behalf, the psychologist on behalf of Mr. Parrish, was to seek a lower sentence, below.
They were trying to justify grounds for a departure.
For a departure. That's why.
What was the ground that the lawyer was arguing for departure then?
You know, I'd have to go back and look, because the initial reason for it was he had him interviewed by a psychologist to talk about his substance abuse issues and some psychological issues. But as we know, when you bring in that stuff, the state gets their shot also. And they took it. And they brought in all that information that guided the attorney in his advice to plead to keep away.
But at the plea hearing, the court specifically pointed out that photographs and witnesses and other things would potentially be heard at the sentencing hearing. Correct?
I don't believe so.
Well, I'm looking at the court's order where the court says, I'll hear whatever argument that the state has to make and the defense. That will take into consideration your history, whether or not you've got other mitigating factors. The state will make argument, present whatever testimony and witnesses they think is important. Maybe some documents or photos, things of that nature can also come into consideration.
Right. They didn't have.
You didn't recall, but that's what the judge warned your client, correct?
Correct, and my client didn't have, and neither did his attorney, have the photos at the time.
I mean, I've looked at the photos, and a lot of what the photos show is that your client got pretty beat up in this process. There's more photographs of him and all the stuff on his body
Right.
than there's of the officers who, one of them's admittedly on a stretcher or whatever with a broken ankle, but it's undisputed, I think, in this case, he has a broken ankle without regard to how that happened. To some degree, I think those photographs are more helpful to your client than harmful because it looks like he got roughed up pretty hard.
They would be very helpful in a trial, Your Honor. But at a sentencing where there is a defendant charged with resisting with violence, you can look at all the photographs of all the little holes in his body from all the taser shots, but just the one photograph of putting the officer on the gurney, I believe, trumps them all in the setting of just, because they weren't there at sentencing to argue the case. They were there to argue mitigating and extenuating and aggravating circumstances. But see, none of that was fully explained. Matter of fact, like I said in the arguments, the reasons for the recommendation to plea was to keep that stuff out. And to keep from hearing the testimony. And I don't think I need, I mean, I'll stand here all day and take the questions.
You've got 3 more minutes for rebuttal if you want to save it for that.
I will save that for rebuttal.
Okay, good. Here from the state.
May it please the court, Peter Koklanis for the Attorney General's office. The defendant in this case pled open, and after receiving his sentence, he filed a handwritten pro se motion to withdraw a plea containing exactly one claim, and I'll quote it for you. My lawyer said I would get probation, not prison time. That was the sole claim contained in the written motion. That was the sole claim filed within the 30-day window for a motion to withdraw a plea. That was the sole claim that the prosecutor was put on notice of prior to the evidentiary hearing and given notice that they needed to respond and call witnesses to rebut at the evidentiary.
Was there any supplemental or written motion filed after the pro se motion?
No, but there was a written argument filed, but let me give you the procedure on that.
Okay.
Basically, the plea happened in October 29th. The 30-day window expires 30 days after. Within that window, a defendant files his handwritten piece of paper on prison stationery saying, you promised me I'd get probation. Then, in February, I believe, well after the 30 days, they have the evidentiary hearing. Counsel asks for leave to file a written argument because they didn't have a transcript. Then, 20 days after the evidentiary hearing, counsel does file a written argument adding some of these new claims about, counsel didn't have the photos. But again, that's well outside the 30-day period, and it's after the evidentiary hearing, so it's too late for the state to now recall their witness and actually ask counsel, did you say that trial was not an option? Did you say this? Why did you do that? So it's our position that those weren't properly litigated below, and if counsel believes they discovered new claims as a result of the hearing, those should have been filed in whatever motions were available, specifically a 3850. And there's actually an interesting exchange.
I guess there would still be the possibility for those things to be raised in a 3850 then now.
There would still be that possibility. I believe the record would refute some of them, but we can debate that, if they actually file a 3850. And there's actually an interesting exchange between counsel and the judge at the end of the evidentiary hearing where counsel specifically says, Judge, there were a few things that came up during the hearing. And what that says to me is that counsel's admitting no one was on notice of these things before the hearing. The state wasn't on notice. The judge wasn't on notice. Counsel wasn't even on notice. And basically these new ideas for new claims came up after. And it's our position that that's not properly preserved. But I am prepared to also address the merits. And specifically, The claim actually litigated below was that counsel promised the defendant probation. I'm not going to spend that much time on that because both the plea colloquy and the evidentiary hearing clearly refute it. Counsel was asked point blank, did you promise him probation? And counsel said point blank, no. Now let's move on to the claims that counsel has, I'm going to call them new claims, specifically claims about the photographs and allowing photographs and witnesses into the sentencing hearing, as well as a claim that you would have, either trial wasn't an option or you would have got a harsher sentence at trial. The claim that counsel was ineffective for allowing these photographs and things into the sentencing hearing, again, first of all, they're all not preserved, but getting to the merits, this claim is not facially sufficient even, because to make a facially sufficient claim, you have to allege both what counsel specifically could have done differently, how he could have done it right, and then you also have to allege prejudice, which usually comes in the form of saying, but for counsel's action in not getting these photos, I would not have pled and proceeded to trial. And I want to emphasize that with every single one of these claims, the photographs, the claiming I would have got a harsher sentence, claiming trial was an option, the defendant never testified, but for counsel's inaction or specific omission, I would not have pled and would have proceeded to trial. And that's important because it's not contained in his written motion. Normally in a 3850, it would be sworn to in their motion.
Did he testify to that at the hearing?
No, he did not. Not as to any of the claims. So it's our position that it's facially insufficient as to prejudice. And it's also facially insufficient as to the ineffectiveness because, you know, they say counsel let these photographs in, but when you say counsel shouldn't have done something, you have to say what counsel should have done. You have to say, you know, counsel failed to object. You have to specify what the objection would have been and then, you know, demonstrate that it would have been sustained or that it had some merit. Here, these photographs had relevance. They were admissible at a sentencing hearing. They would have been admissible at trial because, although counsel has argued they're not, that injury is not an element of resisting with violence, well, guess what is an element? Violence. And these photographs show that violence was done and it came in the form of an injury. An injury is evidence of the violence that happened to the officer. So they were relevant at trial. And here's the reason that argument doesn't even matter, because if the defendant were convicted at trial, he'd have a sentencing hearing after trial. And at that sentencing hearing, the rules would be exactly the same, and the state could have admitted everything, photographs, witnesses, that they did at the open plea sentencing hearing, except that at that point, the judge would have heard a day's worth of testimony and heard the witness, you know, the witnesses would have spent much more time on the stand detailing what happened, and it would have been a much worse position for the defendant.
Did Mr. Parrish testify that his lawyer had told him he was worried about the doctor testifying at trial?
No, no one actually testified that the defendant was told about this doctor. And what's clear from, there's actually 2 pages. The page that the defense cites in their brief, the counsel is basically saying, you know, he concerned about the greater depth of cross-examination on witnesses, the greater detail of testimony that could come out, and then he throws in this point about the doctor could have also testified. It's important to note that on the next page, if you turn to the next page, the defense attorney clarifies, you know, I gave the example of the doctor. He actually uses the term example twice. So it's clear that he's just giving an example of...
Was there a doctor on the witness list?
I don't know. It's not actually contained in the record. I'll take his word that it wasn't on the witness list. But my point is that, well, first of all, you can amend a witness list. You could add the doctor, either as a rebuttal witness or otherwise. And also, even if we just stick to the police witnesses, we've got the 2 witnesses that testified at trial, Russell and Pyers. Russell was the victim, not at trial, at sentencing. Russell's testimony at the sentencing hearing was only 7.5 pages for the state's direct. I think it's obvious that his testimony at a trial would have been longer than 7.5 pages. There would have been greater details coming out, and they also would have called the other witnesses who weren't called at the sentencing hearing. I believe there's an officer listed, mentioned in the sentencing hearing, Corporal Dusky or Dulski. There's another officer, Whedon, and apparently there was like a bunch of officers, tasing the defendant. All these officers would have testified at a trial, and I can't imagine what they would have said about the defendant would have been good. So, as to the argument that counsel let all this bad evidence in the sentencing hearing at the open plea, the fact of the matter is the open plea was still a viable strategy, and in fact it probably was a lot better than the full trial. Yeah, the officer testified about his broken leg, but it was only 7.5 pages, not a full day of listening to witnesses. You know, at a trial, the state could have the officer stand up, show them your foot, show them your scar, you know, act it out, reenact the scene in front of the jury. They could go in painstaking detail. So it's our position that the defense hasn't specified what counsel could have done differently and why. It's not even really counsel's fault because it's the state that admitted these pictures. The state admitted this. If counsel's ineffective, it's simply for failing to object, and they haven't specified what the objection would have been. Now, moving on to the claim that counsel promised or told me I would get a harsher sentence, it's our position that that's also facially insufficient, again, because the defendant never testified, but for counsel telling me that, I would not have pled, and also because that's not per se ineffective. There's two reasons you can get a harsher sentence at trial. One of them would be the improper reason of if the judge vindictively sentenced you, but that's only if he gives you a harsher sentence for exercising your right to trial. That's not what the defendant testified to. He just said, I'd probably get a harsher sentence. And counsel explained, well, that's for proper reasons, legal reasons, knowing all the painstaking details of the case, hearing every little detail, and knowing that you deserve a harsh sentence based on the facts. So it's not inherently ineffective for counsel to advise his clients that trial is risky and these are bad facts, and if these facts come out of trial, it's probably going to be harsher than if we throw ourselves and beg for mercy. And the final point I'm going to make is that the entire point of an open plea was to beg for mercy. Counsel seems to assume that it was to hide evidence and to, you know, not allow the judge to hear any witnesses. I think it's clear it's just to beg for mercy. If you hide evidence, then that's kind of a bonus. You know, it's a simplified version of the trial. It's less. But the real reason is you're accepting responsibility for everything you did. And that's what counsel said that the defendant did. That's what he was advised to do, and that's what he agreed to. So if there are no other questions on any subject, I'll respectfully ask you to affirm.
Okay, thank you. Mr. Cayley?
Your Honor, once again, just like in my reply brief, the state has missed the mark on this. I'm going to go back to my example. I advise a client, if the child testifies and you lose, you could get a harsher sentence. Solid advice, okay? Now let me tweak that a little bit. Maybe I do that because I don't see the child in the courtroom or in the building, or I've been told that the child is not around, and we proceed to sentencing, and then there's the child and testifies, and my client gets the maximum sentence. I've still erred. I've still committed an error in advising my client in that manner. I told him, I'm his lawyer. I told him, it's better if you put yourself in a position where the child doesn't testify. Okay? That's the point. I'm not arguing that the judge did something wrong when they admitted the photographs at the sentencing hearing, or that they allowed the testimony to come in. My argument is the difference between what my client, first of all, the difference between what was in his attorney's mind and what was told to my client 30 days prior to the sentencing hearing. Because that's a long time to go for things to be giving advice about something that you don't know what's going to happen in the end. And that's what happened here. Is his advice was given to induce a plea that turned out to be wrong. Not just wrong, very wrong. So that's the crux of my argument and my argument, misadvice of counsel is inherent in that handwritten request to withdraw the plea. He was saying that he was told he was going to get probation, and he testified to that during the trial.
But did the lawyer confirm that?
The lawyer, he denied it. But the lawyer also said
But if the trial court decides, and we'll accept your plain vanilla first order, because maybe that's what was there, that he just took this on credibility. On that claim, if he believes the lawyer and not the client, what authority does this court have to overrule that?
Well, you've got a lawyer who testified part of his reasonings for recommending the plea, or telling him he had to plea, was the doctor, didn't exist, the photographs, which he didn't have yet, he hadn't even seen them yet, okay? So this is a credibility issue on both sides here. So when you have a credibility issue on both sides, because really this was a dispute between a client and their lawyer over what was said and how the plea was done. But I do know that the lawyer testified that as far as credibility goes, the most important aspect of the testimony is that he testified that the photographs were part of his decision-making process in recommending a plea, and then when asked when he got them the day of the sentencing hearing, 30 days later. So I have an issue with a finding of credibility against my client when the only clear inconsistency during that hearing was from the lawyer.
All right. Thank you.
Thank you. And I ask the court to reverse.
Sure.